5 seconds to go. Start. As per the law, as it existed at their relevant time, the property which was an agricultural property would devolve upon the male child, and daughters would get only a limited right to maintenance till they are married, and the widow would be entitled to maintenance from the income from the property till her death or remarriage. As per the family settlement deed dated 12th March 1938, which was relied upon by both the parties, the property in dispute was specifically allotted to Vedyar and his only son Sukumaran. Therefore, the widow of Vedyar, that is Choyachi, will not have any right over the property. The findings of all the courts below were that Choyachi was never in possession of the property, and therefore she would not get the right as claimed by her under section 14(1) of the Hindu Succession Act 1956. Seen in the light of the ratio of the above judgments, it is clear that for establishing full ownership on the undivided joint family estate under section 14(1) of the Succession Act, the Hindu female must not only be possessed of the property, but she must have acquired the property, and such acquisition must be either by way of inheritance or device, or at a partition, or in lieu of maintenance or arrears of maintenance, or by gift, or be her own skill or exertion, or by purchase, or by prescription. Even on going through the pleadings in the revenue suit for partition filed by plaintiff Kailash Chand, it is clear that there is not even a whisper in the plaint that Srimati Nand Kamarbai or the plaintiff Kailash Chand himself were ever in possession of the suit property. As a matter of fact, the suit was filed by pleading that the suit property was a joint Hindu family property, and defendant Mukatlal, appellant herein, had consented to give half share of the suit property to the plaintiff Kailash Chand on his demand. This assertion was denied by defendant Mukatlal. In this context, when we consider the effect of the earlier civil suit instituted by Srimati Nand Kamarbai, deceased widow, it becomes clear that she was never in possession of the suit property because the civil suit was filed by her claiming the relief of title as well as possession, and the same was dismissed. This finding of the civil court was never challenged. Since Srimati Nand Kamarbai was never in possession of the suit property, as a necessary corollary, the revenue suit for partition claiming absolute ownership under section 14(1) of the Hindu Succession Act could not be maintained by her adopted son, plaintiff Kailash Chand, by virtue of inheritance. On close scrutiny of the judgments rendered by the learned single judge and the learned division bench of the High Court, we find that there is no consideration in these judgments that the predecessor of the plaintiff Kailash Chand or the plaintiff himself were ever in possession of the suit property or had acquired the same in the manner as indicated in the judgment of M. Sivadasan Supra. As a consequence of the above discussion, the impugned judgments do not stand to scrutiny and cannot be sustained. Resultantly, the judgment dated 2nd November 2017, rendered by Learned Division Bench, and the judgment dated 21st July 2006, rendered by the Learned Single Judge, are hereby reversed and set aside. Consequently, the revenue suit number 37 of 1979 filed by the plaintiff is dismissed. The appeal is allowed in these terms. No cost. Stop.